Senate will come to order. Good morning. The senators will please take their seats. Those persons not entitled to the privilege of the floor will retire to the gallery. The senators and all in attendance, please stand and be led in prayer by the Reverend Jonathan Avendano of the Iglesia Magna del Cielo of Sterling. Following the prayer, everyone will please remain standing and be led in the Pledge of Allegiance to the United States of America by Senate Page Clint Wilson of Abingdon.
God bless you. If we could all bow our heads. Father, we come to you in the name of your Son, Jesus Christ, wanting to express gratitude to you for your mercy and grace upon our Senate. Every single one of them was chosen by you for your will and purpose. It's a blessing that all of us of different backgrounds, stories, and ideas can come together for one purpose, the purpose of expanding the prosperity and security of our beautiful state. When we come here, Lord, we ask for your guidance and help to not promote and advocate any man's agenda, ideas, purpose, or system, but to advocate and fight for one agenda, the American agenda, an agenda that advocates for the preservation of our right to life, liberty, and the pursuit of happiness. When we put you in the center of everything, all things are possible. Matthew 6:33 says, "But seek first the kingdom of God and his righteousness, and all these things shall be given to you." This is our mission. This is our prayer. We all agree in the name of Jesus Christ. Amen. God bless you, and God bless the Commonwealth of Virginia.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The clerk will call the roll. All those present, please vote aye. The clerk will close the roll.
You have a quorum, Madam President. Senate Journal for Friday, February 4th, 2022.
The junior senator from Chesterfield, Senator Chase, moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 36, noes 4.
Ayes 36, noes 4. The reading of the journal is waived. The clerk will report any communications from the House of Delegates. Chair recognizes the senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that we waive the reading of the communications from the House of Delegates.
The question is, shall the reading of the communication be waived? All in favor of waiving the reading of the communication will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 5.
Ayes 35, noes 5. The reading of the communication is waived. The clerk will report any communication from the governor.
I do not have any, Madam President.
Now comes the time in the morning hour when we have the honor of welcoming our distinguished guests. What will happen is your name will be called. We will recognize you as you stand up, and then we will hold our applause until afterwards. So, with that, the chair now recognizes the senator from Eastern Fairfax County, Senator Sorovell.
Thank you, Madam President. Good afternoon. And,
Good afternoon.
I rise for an introduction.
The senator has the floor.
Thank you, Madam President. Madam President, I'm honored on your behalf to introduce the body to the Reverend Jonathan Avendano, who is from the Iglesia Mana del Cielo in Sterling. Reverend Avendano graduated from a Bachelor of Science from Duke University, and he's currently obtaining his master's there in theology, medicine, and culture. And you may remember him from the inauguration where he provided the benediction at inauguration. And I would hope that the Senate would give him its warm welcome. Thank you.
Thank you, Reverend Avendano, for coming today and giving us that warm prayer. And senators, let us give him the warm welcome of the Senate. Is there any other business for the morning hour? Seeing none, the clerk will call the calendar.
Senate calendar for Monday, February 7th, 2022. Uncontested calendar. Senate bills on third reading.
Chair recognizes the senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that the Senate bills on third reading on the uncontested calendar, pages 1 through 9, that's Senate Bill 361 through 771, be placed on their final passage in a block. Any senator desiring to remove a bill from the block, please do so after the clerk has read the number of the bill.
The question is, shall the Senate bills on the uncontested calendar, third reading, pages 1 through 9, Senate Bill 361 through 771, be placed upon their final passage in the block with the understanding that any senator desiring to remove a bill from the block will do so after the clerk has read the number of the bill. All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The motion is agreed to. The bills are before us in the block. The clerk will now read the number of the bills.
Senate Bill 361. Senate Bill 56. Senate Bill 84. Senate Bill 94. Senate Bill 191. Senate Bill 195. Senate Bill 221. Senate Bill 289. Senate Bill 426. Senate Bill 434. Senate Bill 469. Senate Bill 508. Senate Bill 684. Senate Bill 698. Senate Bill 726. Senate Bill 771.
The question is, shall the bills in the block pass? All in favor of the passage of the bills will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bills in the block pass.
Regular calendar. Senate bills on third reading. Senate Bill 214, a bill relating to the Virginia Freedom of Information Act, meetings conducted by electronic communication means, situations other than declared states of emergency.
The senator from Prince William, Senator McPike.
Thank you, Madam President. Move that the bill pass and speaking to the motion.
Senator has the floor.
Thank you, Madam President. This is the electronic meeting bill, and this was, I think, fairly well debated last week. Folks have had some opportunity to meet with some of the local officials over the last couple of days, and just one point of clarity. I know that last time, as a part of the debate, one of the questions was, does it apply to the General Assembly? And just to clarify, under sections 2.2, 3707, there's clear language in our code stating that this does not apply. So that's already existing code. Just I want to make sure that those that had the question had that information, that it in fact does not apply to the General Assembly. Madam President, thank you.
The senator from Fairfax City, Senator Peterson.
Thank you, Madam President. Speak in opposition.
The senator has the floor.
Madam President, ladies and gentlemen of the Senate, I do this with great trepidation because I know there's been a lot of work put into this bill, and I have immense respect from my colleague from Prince William County. But lines 383 through 419 of this bill make a pretty radical change in how we have governed ourselves over the past few hundred years by basically allowing public bodies to have virtual meetings outside of a state of emergency, outside of any disability, just based on their own convenience. And I think that's a really treacherous path to go down. I'll give you a specific example. Now, we think of public bodies as being city councils, school boards, and boards of supervisors, but it could also, for example, be a board of zoning appeals. And if you've ever had a client and you appear in front of a BZA, you have no opportunity to speak to them ahead of time. You basically have a few minutes to make your case. Oftentimes, your client's livelihood can be riding on the decision from that BZA. And if you're on some type of Zoom meeting where the camera may not work, they can't hear you, you don't have the opportunity to see them, you don't have the opportunity to actually show them visuals, frankly, it's not substantive due process. And again, I recognize that it's very convenient to have these remote meetings, but people's lives are involved. And I do think if people are going to serve in these positions, unless they're disabled, they really should be expected to show up for work. So I hope we would oppose this bill. Thank you.
The question is, shall the bill pass? All in favor of passage of the bill will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 19, noes 21.
Ayes 19, noes 21. The bill fails.
Senate Bill 371, a bill relating to State Board of Elections membership, appointment of Commissioner of Elections.
Chair recognizes the gentlelady from Fauquier, Senator Vogel.
Thank you, Madam President. I move passage of the bill. And speaking to that motion,
Senator has the floor.
Thank you, Madam President. I will just remind the members of the body that I labored through the details of this bill when we had it on second reading, and the substantive amendments changed the bill. But what we have now is a bill in front of you that would do, I think, the right thing with respect to the Commissioner of the Department of Elections and with respect to the Virginia State Board of Elections, and that is make it truly independent. The goal here is to create an environment where it is no longer operating within the governor's administration, which is effectively how it operates now. It's an even membership. You heard it all before. In the case of a tie vote, the Chief Justice of the Supreme Court appoints a retired judge to break those ties. And it takes 5 of the 8 members to hire or fire the head of the commission. And we addressed the one concern that was raised by one of our members, which was, what do you do if you don't have somebody to act as the head of the agency? And so we added language that designates the director of operations, which is a codified position, and that person would serve as the acting director until such person could be appointed. So with that long explanation, I would ask that the bill please pass.
The question is, shall Senate Bill 371 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Senate Bill 104, a bill relating to elimination of mandatory minimum sentences, modifications of sentence to mandatory minimum term of confinement for felony offenses.
Chair recognizes the junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President, and good morning to you.
Good
Madam
afternoon.
President, I move that Senate Bill 104 pass, and speaking to that motion.
The senator has the floor.
Thank you, Madam President. Madam President, members of the body, Senate Bill 104 is a bill to repeal all mandatory minimum sentences in Virginia. There are currently 224 mandatory minimum sentences. You recall this bill, so I won't go into great detail because it passed this body last year by a 4-vote margin. I will leave one example with you because I think it resonated with several members last year. And that was a situation, and it's just one of so many situations where mandatory minimum sentences did a disservice to people in Virginia. But his name was Nick Robinson. He was 15 at the time of the offense, and he was got involved with several adults. There were 3 or 4 adults, and they robbed a summertime party. They went there. He did not hold a gun. One of the adults did. But they robbed 7 people at that summer party. The adults, including the one that held a gun, entered pleas to various offenses and got sentence ranges from 6 to 12 years, including the person that held the gun. But Nick Robinson didn't plead guilty. He didn't hold the gun. He didn't make any utterances. He didn't encourage or countenance this robbery, but he was there, present, and under the law, aiding and abetting. He pled not guilty, and he was convicted of the 7 robberies. A use of a firearm carries a mandatory minimum sentence for 3 years for the first offense, 5 years for the second offense. He had mandatory minimum sentences of 33 years just for the use of a firearm offenses. And the judge gave that to him. Didn't want to, but gave it to him because he must. Suspended all the robbery time for the robbery. And at this point, he has served over 14 years. The problem, that example by far, certainly isn't the least or the only example. They are legion. So I am asking that this body support SB 104 that will eliminate all mandatory minimums. And Madam Chair, if there are any questions, or Madam President, if there are any questions, I'll try to answer them.
Chair recognizes the senator from Roanoke City, Senator Edwards.
Madam President, speaking in favor of the bill.
Senator has the floor.
Senate Bill 104 eliminates almost all mandatory minimum sentences except for murder of a police officer, I believe. The reason for this is, first of all, we have sentencing guidelines. And the judges do a good job of looking at the sentencing guidelines. And the guidelines, therefore, the mandatory minimum would override the guidelines, which really doesn't make any common sense. And secondly, and the judges are paid to make sure they read the Senate pre-sentence investigation report, look at the guidelines, and make an appropriate sentence accordingly. And the sentencing guidelines, I think, are pretty good guidelines. I think most people agree to that. So we don't want to override what we've already put in place with mandatory minimum, which does away with the philosophy of sentencing guidelines. In addition to that, Madam President, the United States Supreme Court said a number of years ago that for sentencing purposes, the court should look, for due process purposes, look at the history of the defendant and the nature and extent of the crime. Those two things. It's the individual defendant, the history, and then, of course, the crime itself. And based on that, come up with a sentence. Madam President, what we have done with the mandatory minimum over the years is we extended too many of them, for one thing. And secondly, it does an injustice. As the senator from Richmond City, I think the senator from Richmond City also pointed out, it does an injustice unnecessarily. The General Assembly is not the place to do sentencing. We could get the minimum and the maximum sentences on cases. That's our job, to get put in the code what the maximum sentences are for certain cases. But each case is a separate and distinct case, and a judge should be the one to determine what the actual sentence is, again, based on guidelines and based on the defendant's record and history, and of course, the nature of the crime itself. We, as a General Assembly, are not in a position to say, here's what you have to do. And I would hope that the body, as we did last time, just last year, approved mandatory minimum. And with that said, I hope we would agree to support Senate Bill 104. Thank you, Madam President.
Now recognizes the gentleman from Rockingham, Senator Obenshain.
Madam President, speaking of the bill,
the senator has the floor.
The example raised by the senator from Richmond is a very good example of why we should be revisiting mandatory minimums. Okay? I don't think that there is anybody in this body who disagrees with the proposition that we ought to re-examine mandatory minimums. We ought to repeal some of the mandatory minimums. We ought to look at altering other mandatory minimums. But I want to make sure that everybody understands that this repeals every single mandatory minimum in the code. Let me give you an example. These are not all 5-year, 10-year, 20-year life mandatory minimums. A few years ago, I carried a bill to create a mandatory minimum for Section 18.2-60.4. That is in the code, and that is a mandatory minimum for serial violations of domestic violence protective orders. And let me tell you, that's a 60-day mandatory minimum. It isn't a year, it isn't 2 years, it isn't 5 years, it isn't 10 years. And the reason we put that mandatory minimum in the code was because we felt the need to give families some space in cases where a family member is committing violent offenses against the rest of the family. They need an opportunity to cool off. And I cited, when we looked at that, the case of Daniel Lee Zirkle, who on August 2, 1999, had been released from jail for his, third, fourth, fifth violation of a domestic violence protective order. Daniel Lee Zirkle told one of his inmates, and of course this wasn't made known until after the fact, told one of his fellow inmates that when he got out, he was going to take care of all 3 of them when he got out. He proceeded to his home where his two children resided. He murdered one of his daughters in the house and then kidnapped a second daughter and murdered her later in that day. We have got to give families a little bit of space. This repeals that breathing room, that lifeline that we are extending to victims of sexual and domestic violence. Let me give you another one. 18.2-57. It's a 6-month mandatory minimum for assault and battery motivated by race, gender, disability, gender identity, sexual orientation. 6 months. I respectfully submit we ought not be revisiting that. You know, if this bill surgically looked at cases and mandatory minimums such as that which was cited by the junior senator from the city of Richmond, I might very well support this bill. But I cannot support a bill that repeals a mandatory minimum of 1 year for involuntary manslaughter, or involuntary manslaughter by a watercraft, or a minimum of forcible sodomy for 5 years. I think that we need to look at these one by one, and that this is an inappropriate way of doing it. I hope that the members will vote no.
The chair recognizes the gentleman from James City County, Senator Norman.
Thank you, Madam President. I rise to speak in opposition to Senate Bill 104.
The senator has the floor.
I associate myself with the remarks that the senator from Rockingham made, but I'll be a little more emphatic. I think that this legislation is somewhere between being characterized as bad and awful. To reemphasize a point that the senator from Rockingham made, I don't think that we ought to be looking at a global repeal under these circumstances, and that it should be a more focused, individualized attention on each of the potential statutory provisions that it impacts. Second point, I frequently say in committee and sometimes infrequently on the floor, we as a corporate body should never legislate by the most egregious financial circumstances that we can recite, either in favor or against a piece of legislation. I was interested in the comments about the situation involved Nick Robinson, and I will be the first to confess I know nothing about this case. First of all, he had the benefit of knowing what had happened to his co-defendants and the fact they accepted plea agreements. That was an option that was available to him, and he consciously and with his attorney made the choice not to go that route. He made the decision to place his facts and circumstances and mercy before the court. I suggest to you, I was also a little perplexed, and again, I don't know all of the facts of the case, but I was interested in the contradiction of the comments that were made. I practice in this law a little bit, and I am aware that there is the minimum mandatory provisions of a mandatory 3 years on the first conviction of the use of a firearm on a felony. So he had to get that. And then I heard that the balance of the sentences on the remaining charges, which I assume would have been approximately 6, were suspended. But then also I thought I heard that he had served 14 years in the Department of Corrections. So obviously either he had a prior record where he got revoked or something else was going on. I suggest to you, Madam President, that I do think we as the policymakers of the General Assembly are here to see that justice is followed. And we make the policies, and some of those policies can include minimum mandatory sentences, and I think in some of the most egregious circumstances. And I just think it is a significant mistake to try to do this on a global basis.
The chair now recognizes the gentleman from Eastern Fairfax County, Senator Saraville.
Thank you, Madam President. Speaking to the bill.
Gentleman may stay on.
Thank you, Madam President. So we took some testimony on this back during the special session in August. You all might remember back when we were in the Science Museum. And I want to say we took at least an hour testimony, including testimony from some experts who had served on national panels on sentencing. And my recollection is that one of them basically said that mandatory minimums are bad policy because they don't work. They don't deter anybody from crime. They said that most research shows that what deters crime is likelihood of conviction being prosecuted as opposed to the sentence somebody faces. I mean, most people, when they're committing crimes don't, think about, research the criminal code and find the penalty and then say, okay, well, in light of that, I think I'm going to do this now. And so a lot of times these mandatory minimums when they pop up, for those of us that practice, most people have no idea there's actually a mandatory minimum associated with a crime. That's not the kind of information that gets out. They don't reduce drug use. They don't reduce drug addiction. Mandatory gun, just look at where gun crime is today in America, where it's been increasing. And, there's all kinds of mandatory minimums on gun crime. And that doesn't seem to be deterring anybody from using a gun in connection with a felony. And I would just note, Madam President, that across the country, other states have been sort of leading the way in reforming these things, and we're kind of behind the times. Beyond all that, I've been around for, 13 years now, and it seemed to me like in my first few sessions, 2010, 11, 12, 13, we were adopting like 2 or 3 or 4 mandatory minimums every session. And if somebody would have a story and they'd come in and tell the story and people would be like, oh, that's awful. Okay, we'll do that. But there was never any science backing it up. And just to give you an example, I remember one we debated in 2012 on the floor. It had to do with a mandatory minimum on certain kinds of sex crimes. And in connection with that, the Sentencing Commission gives us an analysis of what effect the bill would have, right? And I'm reading from it right now. And they looked at FY 2010 and 2011. And for the category of cases that we were mandating life in prison, there had been 228 sentencing events. And of the total of the 228 sentencing events, 15 people had gotten life. We mandated life for all those cases. So in other words, when juries and judges were presented with information about the nature of the crime, about the victim, when they heard from everybody, the judge and the jury said in 215 cases, we're not going to do life. But instead, the General Assembly walks in and says, no, we think all these people around the Commonwealth were wrong. All these cases deserved life. And that wasn't based on any science or any good policy. It was just based purely on emotion and politics. And that's not how we should be making policy. Madam President, the last thing I'll say is that mandatory minimums, what they do is they basically give prosecutors nuclear weapons to use against people charged with all kinds of different crimes that basically force them to plead guilty. Many people, in fact, I think actually plead guilty to things they're not guilty of because of the magnitude of sentence they're looking at relative to the conduct that's in play. And it basically forces lots of pleas and chills the right to trial by jury. And I would just remind the body that our Commonwealth led the world in codifying the right to trial by jury in our Declaration of Rights back in 1776. We declared our independence from England. And in fact, our Constitution itself says, still today, the right to trial by jury is sacred. And it doesn't use that word anywhere else in the Declaration of Rights. That's not even used in the U.S. Bill of Rights. And this policy that we have today completely undermines that principle that was a founding principle of this Commonwealth. And so I would submit that if you don't trust your judges, let me know. I'm happy to pick them for you. But we have judges that we vet to make these decisions, to decide what the appropriate sentence is. And we shouldn't be making the decision here using this voting box. We should let our judges make these decisions based on the facts and circumstances of every case, talking to the victim, getting a pre-sentence report, and considering all those factors. This is just bad policy, and it's like a bad hangover from the 90s that we need to get rid of today. Thank you, Madam President.
The chair now recognizes the senior senator from Chesapeake, Senator Cosgrove.
Thank you, Madam President. Good morning. Speaking to the bill.
Senator Masayon.
Thank you, Madam President. Ladies and gentlemen, this bill really isn't about deterrence of crime. This bill is deterrence of a milquetoast lenient judge. We have seen in the past, before we had mandatory minimums, where somebody would commit a horrendous crime and receives such a light punishment because, well, they had a hard upbringing, well, they're destitute, well, they have a health issue, whatever. But I will say that I think this bill actually is important to the criminal side and not to the justice side. Also, as mentioned by the gentleman from Eastern Fairfax about the juries being sacred, nobody's touching that. But juries don't sentence; judges do. And I'm not destroying you. Maybe I'm wrong, but I thought that's the way it goes. Anyway, ladies and gentlemen, look, this bill is this is a disaster waiting to happen. And if you don't believe it, watch what happens if it passes. Thank you.
Chair again recognizes the junior senator from Richmond City.
Thank you, Madam President. Madam President, if everybody's been heard, I think it's important that I just correct a few misconceptions. First of all,
The gentleman has the floor.
Thank you, Madam President. Madam President, the senator from Rockingham spoke of a horrible situation involving Daniel Zirkle. But think of what he said. When I get out, I am going to kill them all. Irrespective of if it was 5 days, 5 hours, 50 days, 60 days, when I get out, I will kill them all. And he went on to commit some horrific acts. This legislation has nothing to do with a case like that. The senator from Rockingham is conflating eliminating mandatory minimums to somehow allowing for a horrific act to occur. With regard to the situation with the mandatory minimum that he proposed for a aggravated case of domestic violence, let me be clear. That case may be worth not 60 days, but a year or longer. All we're saying is allow the judge to sentence within that parameter. The gentleman from James City County talked about the math and didn't understand the math. I'll be clearer. My fault. The defendant took a jury trial and was found guilty of 7 robbery counts. The mandatory minimum is 3 years for the first robbery, 5 for every subsequent. 6 times 5 is 30 plus 3. The judge gave him the mandatory minimum of 33 years and gave him no time for the robberies. He had to give 33 years. The gentleman from Chesapeake talked about juries trying and the judge sentences. Well, we've accomplished that because of my bill 2 years ago that took away the sentence from juries and now allow a judge to sentence. And the gentleman is correct. That's a good thing. But don't misunderstand eliminating mandatory sentencing to being lenient on crime. Every defendant has a pre-sentence report, and a judge can sentence well within that range. A mandatory minimum did just what the senator from Eastern Fairfax said. It chilled people's right to have a trial because the prosecutor simply said, if you don't accept this, then we will go to trial, and it is a mandatory minimum. Now, I agree that if you give examples on both ends of the spectrum, that sometimes it's not helpful. But the example that I gave was why we should eliminate mandatory minimums. And do you know who wants to eliminate more mandatory minimums as a body more than anybody? It's judges. Across the board, from our federal judges to our circuit court judges, they don't want their hands tied. You all remember Kimber Smith, a young co-ed that was African-American co-ed that was working at in school at an HBCU. Her boyfriend was involved in drug dealing. She drove him one time to an incident where drug trafficking took place, and she was faced with a mandatory minimum of 240 months. And at sentencing, the federal judge said, I don't want to do this. I have to do that, and imposed a 24-year sentence. She was pardoned after Clinton pardoned her. She was released after Clinton pardoned her after serving 16 years. So let's be real clear what this bill does. It eliminates mandatory minimums, and it says we have faith in the judges to sentence. They can go above or beyond the sentencing guidelines, but we're going to let the judge sentence. And let's be clear, Madam President, what this really affects. It affects brown and black families, and I mean families because the defendant is put away for decades. But it affects brown and black defendants more than anybody else. It began in the 80s and the 90s where people realized you never lost an election because you were tough on crime. And then we went from 4 to 5 to 10 to 20 to 30 to 60, and now we have 224 mandatory minimums. Let's do what we spend so much time in this body do, appointing judges. Let them sentence. Let them sentence to whatever range they want. And I would tell the gentleman from Rockingham that the individual who was involved in domestic violence probably deserved more than 60 days. My bill wouldn't prevent that. The gentleman from James City, referred to an involuntary manslaughter. Maybe 1 year, mandatory minimum is not enough. Involuntary manslaughter is from 1 to 10. Maybe he deserved 5. What we're saying is we're not going to constrain a judge's hands, and we will allow actually justice to grow if you vote yes for this bill. Thank you, Madam President.
The question is, shall Senate Bill 104 pass? All those in favor of the motion for passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 19, noes 21.
Ayes 19, noes 21. The bill fails.
Senate Bill 254, a bill relating to alcoholic beverage control, delivery of alcoholic beverages, third-party delivery license container.
The gentleman from Loudoun, Senator Bell.
Thank you, Madam President. I move passage of the bill and speaking to the motion.
Senator has the floor.
Thank you, Madam President. Cocktails to go. This has been a very important lifeline for many of our small businesses in the Commonwealth. One of my other jobs in service is as the Vice Chair of the Small Business Commission, and we've done some studies on this, and we've lost 25% of our small businesses through COVID. Many of these are restaurants, and frankly, they've been helped by this bill, which was extended to them as a lifeline. We put in guidelines that would make sure that cocktails to go were delivered safely, and that it was done correctly, so we wouldn't have problems. We put together a work group, studied that. It was originally enacted with a 2-year sunset, which is ready to expire this year. So this bill would extend it, and we've also enacted several other new measures as a result of the work group. A couple of things I want to point out, concerns that people have brought to me. Number one, there's a fee in this that's relatively high. There's a $2,500 fee if up to 25 people delivering from a third-party company only. And if it's over 25, it goes to $7,500. Those both are pretty high fees if you look at it compared to other fees in the code for licenses of alcohol. However, I will say many of the licenses are only for one location. A 25 delivery third-party service could be multiple locations, and if you divided that by 25, the fee is actually less than many of the per license places. The $7,500 could be a statewide for an Uber Eats or DoorDash, which could literally be hundreds of drivers. So if you, again, divide it up. I talked with ABC, and they asked for this fee schedule based on the cost of enforcement, the difficulty of enforcement, and regulation, because they have to have many agents in the field to inspect and to make sure this is done correctly. And another point of clarification, those fees only would apply to third-party delivery. It would not apply to a restaurant that would do their own delivery by one of their employees or agents. They would already be covered under their license. With that, Madam President, I renew my motion to pass the bill.
The question is, shall Senate Bill 254 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 4.
Ayes 35, noes 4. The bill passes.
Senate Bill 6, a bill relating to the maximum number of judges in each judicial circuit.
The senator from Eastern Fairfax County, Senator Somerville.
Thank you, Madam President. I move the bill pass, and speaking to that motion.
Senator has the floor.
Thank you, Madam President. Senate Bill 6 just authorizes an additional circuit court judgeship for Prince William County. Well, technically it's Prince William County, Manassas Park, the 31st Judicial Circuit. Right now, Prince William is dealing with a significant backlog of cases that dates back to 2015. They've had a big increase in civil jury trials, complex motions. Prince William has more domestic relations cases than any other circuit except for Fairfax. And for those of you who don't know how divorce practice works in Northern Virginia, it's a pretty hotly litigated area that results in a lot of long hearings and a lot of time in front of judges. Prince William County also, I would just note, there have been some conversation about the weighted caseload study. First of all, the data that was given by Prince William had some inaccuracies in it, which was presented to the Judicial Council. But in addition to that, Prince William and Manassas Park has actually grown by about 10%, by about 50,000 people since the weighted caseload study was done. And this was all presented to the Judicial Council, who considered all of this and authorized an additional position. This additional position was not my idea. The Judicial Circuit asked for it. The Council looked at it. All the processes that we normally use were followed on this. They were found it was justified, and Governor Northam funded it in his budget. So there's no money issue on this either. So I would hope that we would adopt this bill. Thank you.
The question is, shall Senate Bill 6 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 4.
Ayes 35, noes 4. The bill passes.
Madam President.
The senator from Roanoke County, Senator Suderline.
Thank you, Madam President. Having voted on the prevailing side by which we just agreed to pass Senate Bill 6, I ask that vote be reconsidered.
The question is, shall the motion by which Senate Bill 6 passed be reconsidered? All those in favor of the motion will say aye.
It's recorded.
I'm sorry, it's a recorded vote. All those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 39, noes 0.
Ayes 39, no 0. The bill is reconsidered. Again, the senator from Eastern Fairfax County.
Thank you, Madam President. I move the bill pass for the reasons previously explained.
The question is, shall Senate Bill 6 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 35, noes 5.
Ayes 35, noes 5. The bill passes.
Senate Bill 138, a bill relating to discovery in criminal cases, copies of discovery for the accused.
The gentleman from Roanoke City, Senator Edwards.
Madam President, I move that the bill pass.
The senator has the floor.
And by speaking to the bill, Senate Bill 138, very simple bill. Last year, or a couple of years ago, I can't remember when, we provided that the prosecutors should provide discovery to the defendant in a criminal case. What had happened is most of them are very We'll fax it to you, email it to you, or maybe even mail it to you. But there are some cases that have come up where the prosecutors have said, come to the office, fix it, make your own copies. And I don't think most people want to have to drive 50 miles or wherever it happens to be to go to the prosecutor's office to pick up the discovery. And so all this bill does, it makes it clear that prosecutor, the defendant is entitled to receive the discovery, and the prosecutor is required to provide it, copies to the defendants. It could be done electronically, email, or faxes. And the prosecutor has to review the discovery anyway. So the idea of having to go to the office and waste the time, especially for court-appointed attorneys and people like that, makes no sense at all. So this would require the prosecutors, either through email or faxing or whatever method may be easy to do, to provide the discovery that the defendant is entitled to get. That's all it does. With that explanation, I move the bill pass.
The question is, shall Senate Bill 138 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 23, noes 17.
Ayes 23, noes 17. The bill passes.
Senate Bill 153, a bill relating to Governor's Office, position of Secretary of Diversity, Equity, and Inclusion created.
The gentlelady from Hampton, Senator Law.
Thank you, Madam President. I move that Senate Bill 153 pass and speaking to that.
Senator has the floor.
Thank you, Madam President. In 2020, the General Assembly formally voted to establish the position of the Director of Diversity, Equity, and Inclusion in the office of the Governor. What Senate Bill 153 does is to elevate that position to the Secretary of Diversity, Equity, and Inclusion to be appointed by the Governor and to assist the Governor and governor's secretaries in promoting diversity, equity, and inclusion at the state level. The bill also outlines the responsibilities of the secretary. And I move again that Senate Bill 153 pass.
The question is, shall Senate Bill 153 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The bill passes.
Senate Bill 158, a bill relating to Virginia Black, Indigenous, and People of Color Historic Preservation Fund established.
The senior senator from Chesterfield, Senator Hashmi.
Thank you, Madam President. I move that SB 158 pass, and speaking to that motion.
The senator has the floor.
Thank you, Madam President. SB 158 seeks to establish the Virginia Black, Indigenous, and People of Color Historic Preservation Fund. Presently in Virginia, we have the Virginia Land Conservation Foundation, the Virginia Battlefield Preservation Fund, the Virginia Outdoors Foundation Preservation Trust Fund, and all of these entities provide grants which are dedicated and to dedicated ongoing programs that target the acquisition and protection of battlefields, farmlands, parks, forests, and natural areas. But we currently have no grant fund that targets the Black, Indigenous, and People of Color's cultural and historic sites. And a recent analysis of these existing grant programs revealed that very little funding is actually benefiting properties that are historically associated with what we call the BIPOC community. And so the creation and funding of this grant program is the next step for us in the Commonwealth to commit and preserve these very critical sites. Madam President, I would argue that we preserve what we value. And it's truly time that in the Commonwealth we value the full history of our Commonwealth and that we make sure that we preserve it for future generations.
The question is, shall Senate Bill 158 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 28, noes 12.
Ayes 28, noes 12. The bill passes.
Madam President.
The gentleman from Williamsburg.
Yes,
Senator Mason.
Thank you, Madam President. Before we get along too far, if having voted on the prevailing side by which we passed Senate Bill 254 on page 12, I'd like to move that we reconsider that vote.
The question is, shall the vote by which it passed be reconsidered on Senate Bill 254? Those in favor will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. It is reconsidered. Again, Senator Bell.
Thank you, Madam President. Having previously spoken to the bill, I renew my motion to pass the bill.
Question is, shall Senate Bill 254 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 38, noes 2.
Ayes 38, noes 2. The bill passes.
Madam President. Over here. Madam President.
Senator from Hanover.
Madam President, having voted on the prevailing side by which Senate Bill 158 on page 14 passed, I move that we reconsider the vote. 158 on page 14.
Question is, shall the vote by which it passed, that is Senate Bill 158, be reconsidered? All those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, noes 0.
Ayes 40, no 0. The bill is reconsidered. The senior senator from Chesterfield, Senator Hashmi.
Thank you, Madam President. Having previously spoken to this motion, I move that we pass SB 158.
Question is, shall Senate Bill 158 pass? Those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their votes? The clerk will close the roll.
Ayes 30, noes 10.
Ayes 30, noes 10. The bill passes.
Senate Bill 196, a bill relating to alcoholic beverage control, Virginia Spirits Promotion Fund funding, tax allocation report.
Senator from Williamsburg, Senator Mason.
Thank you, Madam President. Madam President, I move Senate Bill 196 pass. And speaking to the motion.
The senator has the floor.
Thank you, Madam President. 2 years ago, we passed a bill that established the Virginia Spirits Promotion Fund. Came along last year and tried to figure out a way to fund it, and that did not go so well. But the board got back together. They agreed on the way they wanted to go about doing it. And so we are excuse me, Madam President. We've set this up just like the Virginia Wine Promotion Fund. So 20% of the collected excise tax will go back their way. And in committee, we amended it to make sure that we get reporting back. How's the money spent? How efficient it, and how effectively is the promotion of the Virginia spirits done? And so with that explanation, Madam President, I move the bill pass.
The question is, shall Senate Bill 196 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Senate Bill 250, a bill relating to non-hazardous solid waste fees.
Senator from Eastern Fairfax County, Senator Somerville.
Thank you, Madam President. I move the bill pass, and speaking to that motion.
The gentleman has the floor.
Thank you, Madam President. Ladies and gentlemen, this bill evolved out of some discussions that occurred last year in the Ag Committee. My seatmate here carried a bill to increase fees, and that bill got, I guess, tabled or PBI'd or whatever you want to say. And DEQ set up a work group with the landfill industries to come up with a fee structure that would support all of the solid waste permitting and enforcement efforts. And so the work group met over the last 12 months. They arrived at a consensus, and that's what this bill does. Basically, right now, they collect about $2.9 million in fees to fund the program. This, which is about a third of the $6.8 million budget cost. This basically raises the fees in various strategic ways on different annual permitting requirements and whatever applications and whatnot to cover the entire program with these fees. And that's basically all the bill does. So it's going to save taxpayers, I guess, about $3 million and make the industry support itself in terms of its regulation. So I'd hope the bill would pass.
The question is, shall Senate Bill 250 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their votes? The clerk will close the roll.
Ayes 24, no 16.
Ayes 24, no 16. The bill passes.
Senate Bill 270, a bill relating to administration of government, language access equity report.
The gentlelady from Chesterfield, Senator Hashmi.
Thank you, Madam President. I move that SB 270 pass. And speaking to that motion,
Senator has the floor.
Thank you, Madam President. One thing that we learned during this COVID crisis is that we have serious barriers to access in terms of all of our communities being able to reach our state agencies and receive the support and the resources that are critical for them, whether they are in areas of healthcare, education, or the wide variety of social services. SB 270 seeks to address that serious concern by creating an interagency language access working group that would establish and maintain a model language access policy for all of our state agencies to use. And this working group would work with each state agency's language access coordinator, an individual already working within the agency who would be so designated, in order to track progress that's being made by each state agency to ensure that language access needs are being met. We would also ask this working group to produce an annual report to both the governor and to the General Assembly so that we can create sufficient data and understand what kinds of support and resources we are able to provide to all of our Virginia communities and make sure that they are accessible in languages that are dominating in each of our critical areas. So, Madam President, I move that the bill pass. Thank you.
The question is, shall Senate Bill 270 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 19.
Ayes 21, noes 19. The bill passes.
Senate Bill 425, a bill relating to barrier crimes.
The gentleman from Roanoke City, Senator Edwards.
Madam President, I move that Senate Bill 425 pass.
Yes, sir.
And by speaking to the bill,
The gentleman has the floor.
this grew out of a joint subcommittee to study barrier crimes and criminal history records checks. The committee recommended strongly that something be done with regard to barrier crimes to give people an opportunity to work. Let me explain to you what a barrier crime is. A barrier crime is a crime that bars you as a barrier to working in certain categories, schools, daycare centers, nursing homes, or whatever it happens to be. And the categories are set forth, and they're not all the same. If you work in certain types of businesses in the regulated by the Department of Behavioral Health and Developmental Services, or the Department of Education, or the Department of Health, or the Department of Social Services, there are certain crimes that bar you from working these particular occupations. They're not all the same. The Department of Health has different barrier crimes than the Department of Education, for example. They're different, and there are quite a few of them. The joint subcommittee recommended, and by the way, there are 16 other states that are doing something similar to this, but the joint subcommittee recommended, first of all, eliminating some misdemeanors, but not very many, retaining all the felonies, but at the same time providing a waiver process, administrative process, that a person wants a job in a certain category but committed a certain crime can still ask for permission through the departments to get a waiver so they can work in these categories. And so the waiver process, again, 16 other states are doing something similar to this. And the waiver, if you get a waiver from the Department of Education to work in a certain category, it wouldn't transfer to another agency. So each of these different departments would come up with their own categories of waivers, and if you get a waiver from one department, that does not mean that you get a waiver in another department. And it also provides that if a person is denied the waiver, the department would have to explain why, and there's an administrative process under the Administrative Processes Act where a person can appeal. Many people have been denied the right to work in certain categories. I know, for example, I had a case not too long, a number of years ago, a child care agency. The person was denied the right to work in the child care agency because 25 years ago, I believe it was, he and his brother got in a fight, and they were both convicted in General District Court, and it barred them for life from ever working in certain categories. So I know many people have voiced the view that nobody should be barred from life for working in a certain type of occupation, and so this would provide people with an opportunity to file a petition for a waiver with the particular departments involved. And with that explanation, I move that the bill pass.
The gentleman from Fairfax City, Senator Peterson.
Thank you, Madam President. If I may speak in support of the bill.
Senator has the floor.
Ladies and gentlemen of the Senate, I was going to keep my mouth shut today, but I got to speak in support of this bill just because I have had situations where this has come up, and it's important that we allow people in this situation some flexibility. And let me give you an example. I have a friend, somebody I knew. We played rugby together, and had an assault conviction when he was young. He was an adult, but he was young. And since that time, he's my age, got married, got his act together, has a successful business, and he wanted to coach his daughter's high school volleyball team because nobody else would do it. So they could have a team. His daughter could participate. He wanted to do it. But because he had a conviction from the time he was 19, 20 years old, he was faced with a barrier. Now, he happened to know a lawyer, me, and we figured out a way to get around it. To be honest, it was a little bit dicey, my legal reasoning, as usual. But we finally got the schools to accept that. But it was scary, the idea that these girls would have had to discontinue their club simply because of an incident that had completely irrelevant to what the merits of the situation were. So I really hope that we will pass this bill with some good green votes on it, send it over to the House, and talk to our friends over there, because I do think this is the right thing to do. Thanks.
The senator from Rockingham County, Senator Obenshain.
Madam President, rise to speak to the bill.
The senator has the floor.
Madam President, members of the Senate, I don't disagree with my friend from Fairfax City when he says that somebody who maybe was engaged in youthful hijinks, maybe wrong place, wrong time, maybe inappropriate conduct in which he gets an assault conviction at 18, 19, 20, I don't disagree that they shouldn't be on this barrier crimes list. And this bill has the same problem that the mandatory minimum repeal bill had. It is way too broad. And I would point out to the members that this, among the other things that this does, it amends the section creating barrier crimes for employees or volunteers providing care to children or the elderly or disbanded or disabled. One of the crimes that has been removed from the list of barrier crimes for providing care to children is kidnapping. Another crime that has been removed from the list of barrier crimes here is crimes against nature. I mean, are you serious? Do we really believe that somebody who's been convicted of crimes against nature ought to be removed from the barrier list of people who are eligible to take care of children as employees or volunteers in a child care setting? You know, again, if we were just talking about removing assault and battery or unrelated offenses that don't have a direct connection to somebody's fitness to provide care in these settings, I would support this bill. But I submit that this kind of broad approach is an approach that is going to seriously endanger children and other vulnerable people this was intended to protect. So I would hope that people would vote no.
The gentlelady from Arlington, Senator Favola.
Thank you, Madam President. I rise to speak in favor of passage of this bill.
The senator has the floor.
Thank you, Madam President. We've heard this bill several times, actually, in the Rehabilitation and Social Services Committee, and I just want to remind the body that this bill requires a two-step process. It is not a blanket waiver of all barrier crimes. This allows barrier crimes to be placed on a list, but agencies must create a waiver process. So the Department of Education, the Department of Social Services, the Department of Behavioral Health and Social Services would each establish a waiver. So it doesn't mean that everybody would be eligible for any job. That's not what this bill does. And that's important to know. What it does do is it opens the door, for example, individuals, again, who have done their time, who have remained clean. They may have a record relating to substance use and abuse. They may be eligible under certain conditions, and it can be rather a rigorous application or a rigorous waiver process. They may be eligible to apply for jobs as a peer counselor. We have a shortage of counselors. Studies show us that peer counselors are particularly effective in guiding people who they were in the same place as the folks they were guiding, and they can relate, and they can make a difference in people's lives and they can contribute. And that's really important. We're opening a door. We're opening it carefully. And finally, I just want to note, the Brennan Center for Justice did a study on the removal of barrier crimes. And this really is a very important social equity move. So according to this study, which was very recent, 9 out of 10 employers look at somebody's past record. 3 out of 5 colleges and universities. 4 out of 5 landlords. I mean, this is an opportunity to really enable somebody to start a new life, which is part of our philosophical view about rehabilitative justice. And we have enjoyed bipartisan support endorsing the concept of rehabilitative justice. This is a step in the right direction, and I really would encourage the body to support this bill. Thank you, Madam President.
Again, the gentleman from Roanoke City, Senator Edwards.
Madam President, with nobody else wishes to speak,
Senator has the floor.
I'd like to point out to my friend from Rockingham County that this is not an automatic anything. There are a few misdemeanors that are removed from the list. All the rest are still on the list. And all the waiver process is the departments have to approve it, and the employer, if you want to work for somebody, would have knowledge of this, and the employer would not be required to hire anybody. But this would allow people who otherwise want to work in a certain category and are otherwise qualified to do so, to not be barred for life. This is a lifetime bar. In this country, we have the right to life, liberty, and property, and having a job is an employment right. And this bars people from having a right to have certain jobs available to them. And all this does is it has by the way, a delayed process to 2025, I believe it is. The state police will be involved. Again, all it does is give people the opportunity, if the employer wants to hire them, to go through a waiver process with the departments to be approved for these to have a waiver of a lifetime bar from working in a certain category. With that explanation, I move the bill pass.
The question is, shall Senate Bill 425 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 22, noes 18.
Ayes 22, noes 18. The bill passes.
Senate Bill 449, a bill relating to qualified health plans, essential health benefits, state-mandated health benefits.
The gentlelady from northwestern Fairfax County, Senator Boysko.
Thank you, Madam President. I move that we pass SB 449. And speaking to the bill.
The senator has the floor.
Thank you so much. Ladies and gentlemen, in 2020, we passed a bill that would allow children with rare inherited metabolic disorders have access for prescription coverage for medically necessary formulas. The Centers for Medicare and Medicaid Services stated recently that the requirement would be a new health insurance benefit rather than an expansion of an existing benefit. So this bill is absolutely necessary to continue those benefits for our children on our Virginia plans. We passed the policy unanimously 2 years ago, and I move that SB 449 pass today in order to help people with inherited metabolic disorders.
The question is, shall Senate Bill 449 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? clerk will close the roll.
Ayes 40, no 0.
Ayes 40, no 0. The bill passes.
Senate Bill 551, a bill relating to flood resiliency and protection.
The senator from Western Fairfax County, Senator Marsden.
Thank you, Madam President. I move that the bill pass. And speaking to that,
Senator has the floor.
thank you, Madam President. Senate Bill 551. This legislation establishes that the Department of Conservation and Recreation, known as DCR, shall serve as lead administrator of the statewide flood protection plan and the Virginia Coastal Resilience Master Plan. DCR shall also have the responsibility to implement both plans. The legislation provides minimum criteria for development of the flood protection plan and updates the Virginia Coastal Resilience Master Plan, which was released in December of 2021. The bill also requires that the plan be updated every 5 years. It creates a technical assistance council for and includes in that the membership and duties of that council. And it also deals with community outreach to vulnerable and all community elements to make sure that everyone is covered in the master plan, and it requires a report to the General Assembly every 2 years, as well as to the governor. And DCR is under the bill is also authorized to use funding from the Community Flood Preparedness Fund for studies of statewide or regional significance. And with that, I renew my motion that the bill pass.
The question is, shall Senate Bill 551 pass? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their votes? The clerk will close the roll.
Ayes 24, no 16.
Ayes 24, no 16. The bill passes.
Senate Bill 652, a bill relating to absentee voting, application requirements, last 4 digits of Social Security number.
Gentlelady from Fauquier, Senator Vogel.
Thank you, Madam President. I move passage of the bill and speaking to that motion.
Senator has the floor.
Madam President, what this bill does is seeks to address a challenge that we had in the most recent statewide elections, and that is the application of the rule related to your application for an absentee ballot. It has been the position of the registrars in the Commonwealth of Virginia and remains their position that the statute in Virginia is very clear, and that when you're asked to fill out this application form, at the very top it asks for your name, your birth date, and your Social Security number. What's required is only the last 4 digits, but every registrar in the Commonwealth until this election applied the law the same, and they said if you did not have that information, that was a material omission, if you lacked the Social Security number information, in this case the last 4 digits. And so those were set aside. Our registrars have said the statute is 100% clear, and more importantly, if a person isn't there in front of me in person and I don't have the last 4 digits of a Social Security number because it comes through the mail, how else am I to be sure that it's the person that they say they are, and that I am in fact returning a ballot to the right person? The issue arose when Fairfax decided to apply the law differently. And the reality is that it doesn't matter what your position is or what we think the policy should be. What matters is that in the Commonwealth of Virginia, that we apply all the laws the same. Uniformity is critical. So it isn't fair that everybody else in the Commonwealth of Virginia should have the registrars follow what they unequivocally believe to be written in the code, and that another jurisdiction should act differently. Now, it is not the fault of the registrar in Fairfax County, actually, because he sought guidance from the Department of Elections. And the Department of Elections issued guidance that indicated that he would be able to do this. When I asked the other registrars in the rest of the Commonwealth of Virginia, well, how can you justify that we are treating one county one way, absentee voters one way in one county, and not the same in every other county? And their response was, it doesn't matter. Guidance doesn't override a statute. We are not going to change our position. And honestly, that is the correct answer. Guidance should never override statutory language. So in conversations with registrars around the Commonwealth and with people smarter than I, what is the right solution? The solution is to make it very clear and add one sentence. The applicant's failure to include the last 4 digits of a Social Security number on the application will be considered a material omission. I think anybody who reads this statute knows that that is implicit. A material omission has to be one of the things in this top number 1 box. And so with that, Mr. President, I want to thank the registrars who worked with me on this. I did, during the election, have the opportunity to speak to the Fairfax County Registrar. He is eminently qualified. He comes from Utah and has an extraordinary amount of election law experience and understanding. And in our conversation, one of the things he said is, I hope that when you guys go back to session, you will clean up this part of the code. So anyway, this is my effort to address that so that at a minimum, we have uniformity. Thank you, Madam President.
The gentleman from Alexandria, Senator Eben.
Thank you, Madam President. Would the senator from Fauquier yield for a question?
Will the senator yield?
Madam President, I'm happy to yield.
I would ask the senator if she said that the Fairfax County Registrar asked if we would clean up the code. It was my understanding that Fairfax County actually is not in support of this bill and in fact testified against this bill in the Privileges and Elections Committee. Is that right?
Madam President, when I spoke, yes, Madam President, Fairfax County is not in support of this bill because they are operating differently than the rest of the registrars. He did say in my conversation, Madam President, that he would be very grateful if we cleaned up this section of the code to the extent that there's any question. So this is my effort to do that. Thank you.
Senator Eben.
Would the senator yield for another question?
Yes.
Senator from Fauquier.
Madam President, I absolutely yield.
Senator Eben.
I would ask the senator if she's reviewed the handbook that's given to all the registrars about what to do when there is an omission.
Senator Vogel.
Yes, Madam President, I have reviewed that in great detail and actually consulted registrars around the Commonwealth of Virginia on that handbook and how it is that they apply the law and interpret the handbook. And, Madam President, if I may take it one step further and probably answer the gentleman's question, the registrars have said that consistent with the code, notwithstanding guidance or anything else that might be interpreted from the handbook, they will apply the code, full stop.
Senator Eben.
Speaking briefly to the bill.
The senator has the floor.
I just want to be clear that what Fairfax County did after getting guidance from the State Board of Elections Council was they didn't just count the absentee ballots or honor the absentee ballot request forms that came in without a absentee ballot, but rather what they did is they emailed people or called them and said, you left this part of the form blank. Can you give me the last 4 of your socials? So they, in fact, verified them. There was no funny business going on. And what we're going to be doing if we pass this is see that some absentee ballot requests or more absentee ballot request forms just can get thrown out right away rather than seeking to verify the information. Thank you.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Would the senator from Fauquier County yield for a question?
Will the senator yield?
Madam President, I'm happy to yield.
Senator Morrissey.
Thank you, Madam President. I was thinking about possible scenarios that this could occur in when you were given your explanation, and I would preface my question with the following. I agree with you. Fidelity to the law and guidance are often two different things. But is it possible now for an outside entity to help harvest absentee ballots without the individual themselves requesting the ballot? In other words, can an outside group decide to get a large group of people, maybe in some particular industry or some particular area, geographical area, and ask them to request an absentee ballot by preparing most of the ballot for them and then sending them the absentee ballot application.
Senator Vogel.
Yes, Madam President, if I may follow up on his question. He is very, very right about that, and that was in part a catalyst for a major component of what presented itself as the problem, and that was many voters who received the pre-populated sheet simply mailed it in and didn't read to the final piece, which was fill in your last 4 digits of your Social Security number. So the gentleman is absolutely correct that that is, in fact, making this worse and creating this larger issue, and why it was even worse in the Commonwealth of Virginia if you have one jurisdiction applying the law one way and the rest of them applying it differently. It makes for a lack of uniformity that I think is a real fairness issue in the Commonwealth.
Would the
Senator Morrissey.
Would the gentlelady yield for another question?
Another question, Senator Vogel.
Yes, I'm happy to yield.
Senator Morrissey.
Because the citizens often have, there's a database out there with the last 4 digits, but not the entire 9-digit Social Security number. Why aren't we requiring the applicant to put down the entire 9-digit Social Security number when he or she files an application for an absentee ballot, as opposed to an organization that harvests the ballot? It doesn't make any difference whether it's conservative or liberal, but harvests the ballot, sends them to the citizens, and then simply say, sign the application. Why stop at just the last 4 digits? Why not make the applicant put the entire 9-digit down there? Because that would stop an outside entity that has a database of only the last Social Security numbers from harvesting these ballots.
Senator Vogel.
Madam President, I would respond by saying there has been legislation to make that the law. In fact, it used to be, and then it was revised to make it the last 4 digits. The issue that he is pointing out is precisely the issue that we have. When somebody is mailed a pre-populated form and they mail it back in, they assume that the material information has been included. It has their name and their birth date. But the registrars would tell you that according to the code, that's not enough to verify the identity of the person who's sending in the absentee ballot application. So what you get is a flood of these that have been mailed out to people. They see it, they send it in. Many of them are not actually sure what they're sending in. That's clear to me. But the ultimate problem is, yes, irrespective of the policy position that we might take on what identifying information must be there, how much of your Social Security number, yes, I would argue, and every registrar that I've spoken to has said, this is critical information to me. So, yes, I would say what the gentleman says is correct. But the bigger issue is that if every registrar, and I hate to be redundant, every registrar takes one position and is emphatic that that is the law, and by virtue of guidance, it allows for one extraordinarily large locality to do it differently and accept them without that and not consider that material information, then again, we have something that is just fundamentally not fair and imposes a whole different set of rules on one part of the state and a different set on another. And I think that lack of uniformity is terrible in the Commonwealth of Virginia.
I thank the senator.
Thank you, Madam President.
The gentleman from Eastern Fairfax County, Senator Sorovell.
Thank you, Madam President. Speaking to the bill.
The senator has the floor.
Thank you, Madam President. You might note from the calendar that I appeared to have voted yes for this by proxy, which I apologize for on behalf of my proxy person. But I don't like this bill, and explain to you why. Back in 2015, you all might remember that Speaker Howell went to the Board of Elections and got authority from them to do electronic absentee ballot applications. And the State Board of Elections approved those. Basically, you could set up a website to collect the information, then put it in an Adobe a PDF of an application and electronically sign it. And in 2015, I took that and created my own app, and I went around. I signed up about 950 people to vote, to apply to vote absentee electronically. And having talked to those 950 people at their door and asked them for their information and to put it in the website or the app, I will tell you the number one thing people got queasy about, actually probably the only thing they got queasy about, happy to tell me where they worked, who their employer was, their commuting hours, lots of other things. The last four, the social, was the thing that hung people up. People got concerned, I don't feel comfortable giving you the last four of my social. And what I would usually do is tell them, well, here, you take my tablet, you put it in yourself, then you hit the button, I'll never see it. And that's how we handled it. And that made people comfortable that I didn't see it. And I'm telling you that some people just don't feel comfortable putting the last four of their social on a piece of paper that other people are going to see because of the concerns that are out there about identity theft, and those are valid concerns. I've heard from the registrars that they like to see the last four just because it helps them verify things. One of the weird things about our Constitution is actually the Constitution of Virginia actually says that you have to provide a full Social Security number to register to vote in Virginia. I've actually tried to change that a couple of times with the constitutional amendments, but it's never passed. But I just don't see the need that you have to have the last four to verify it. When you got a name, you got address, you got phone numbers, you can contact people with the information they provide to verify it's them if you're really that worried. But it's a Class 5 felony to impersonate a voter filling one of these things out. I mean, I think that's sufficient deterrent to anyone in terms of submitting one of these. And we just haven't had a problem in Virginia with people falsely filing absentee ballot applications. I've seen a problem, for example, in a race in North Carolina where they had it, but not in Virginia. And so, I think the registrars just need to get comfortable with what they got, and I think Fairfax is doing it right. This bill, to me, is a solution in search of a problem, and if we pass it, I tell you, it's going to result in a lot of people filing for their absentee ballot applications and not getting it or not realizing why they didn't get it. It's going to result in people not being able to vote. That's what's going to happen, and I would hope we would vote against this.
Gentlelady from Northwestern Fairfax County, Senator Boysko.
Thank you, Madam Chair. I'd just like to follow up on something that the senator from Alexandria mentioned. In 2020,
the senator has the floor.
Thank you, ma'am. In 2020, we passed a bill that allowed people to provide their phone numbers and their email addresses in case there was some sort of an error in their applications. This allowed the registrars to go back and verify and make certain that they had the proper information if something was omitted or was incorrectly added. I see this as rolling that back. In Virginia, we should all be standing together to expand access to casting our ballots. I hope it is the pleasure of the body to reject this bill. I see it as moving us backward. Thank you.
The senior senator from Richmond City, Senator McClellan.
Thank you, Madam President. Would the senator from Alexandria yield for a question?
I yield.
Senator McClellan.
Thank you, Madam President. Under the legislation that the senator from Herndon just referenced, if an absentee ballot application has a material omission, aren't the registrars required to contact that person and allow them the opportunity to cure that application?
I know that they're required to cure the absentee ballot that's returned if it's lacking some information on the envelope. I don't know about the absentee ballot application itself, if that is part of the cure process.
Could the senator
McClellan.
Could the senator from Fauquier rise for a question?
Will the senator from Fauquier rise?
Madam President.
Senator McClellan.
Is that your, if there is a material omission on an absentee ballot request, under your bill, would there, regardless of what that omission is, under this bill or under current law, is there a mechanism for the registrars to contact that voter to tell them of that omission and give them an opportunity to correct it?
Senator Vogel.
Madam President, I'm not aware of anything that that prevents the registrars from doing that right now. That fundamentally is the issue as we have it. We spoke about the fact that it calls for all this other identifying information, but the one critical piece that the registrars say they must have to identify the voter, because the address may be different, something else may be different, but they consider this to be the one way to go back and match it with the voter's registration because they get the Social Security number when they register. This bill doesn't change that. It doesn't change the law. And to the gentle lady's question, it certainly doesn't do anything except, I would assume, if there's any ambiguity, create the environment where it makes it absolutely clear that that's material and you have the opportunity to go back and ask the voter to make that cure.
I thank the senator.
The question is, shall Senate Bill 652 pass? All those in favor of passage will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 29, noes 11.
Ayes 29, noes 11. The bill passes.
Senate Bill 678, a bill relating to definition of agricultural operation.
Senator from King George, Senator Stewart.
Thank you. Just let it go right now.
Thank you, Madam President. Something wrong with my string again. Madam President, I'd move the bill pass, and speaking to that.
The senator has the floor.
Thank you, Madam President. This bill very simply makes it clear that the definition of an agricultural operation includes having livestock, and that's the bill.
Shall Senate Bill 678 pass? All those in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll. Ayes 37, noes 2, rules 36-1. The bill passes.
Uncontested calendar. Senate bills on second reading.
Chair recognizes the senior senator from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills on second reading on the uncontested calendar, it's pages 19 through 24, Senate Bill 23 through 724, be advanced to their engrossment and third reading in a block after the adoption of any amendments thereto. Any senator desiring to remove a bill from the block, please do so after the clerk has read the number of the bill.
The question is, shall all Senate bills on second reading on the uncontested calendar on pages 19 through 24, Senate Bill 23 through Senate Bill 724 be engrossed and advanced to their third reading in the block after the adoption of the amendments thereto, and that any senator desiring to remove a bill from the block do so after the clerk has read the number of the bill. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The clerk will now read the number of the bills.
Senate Bill 23, reported from the Committee on General Laws and Technology with a substitute.
Chair recognizes the gentlelady from Hampton, Senator Locke.
Madam President, I move that the substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor will say aye. Those opposed, no. The substitute is agreed to.
Senate Bill 69, reported from the Committee on General Laws and Technology with a substitute.
Gentlelady from Arlington, Senator Favola.
Thank you, Madam President. Madam President, I move that the substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye. Those opposed, no. The ayes have it. The substitute is agreed to.
Senate Bill 96, reported from the Committee on General Laws and Technology with amendments.
The senator from James City County, Senator Norman.
Thank you, Madam President. I move that the committee amendments be agreed to.
The question is, shall the committee amendment be agreed to? Those in favor of the motion will say aye. Those opposed, no. The amendments are agreed to.
Senate Bill 169, reported from the Committee on Education and Health with amendments.
Senator from Lynchburg, Senator Peake.
Yes, thank you, Madam President. I move that the committee amendments be agreed to.
Question is, shall the committee amendments be agreed to? Those in favor of the motion will say aye. Those opposed, no. The amendments are agreed to.
Senate Bill 202, reported from the Committee on Education and Health with amendment.
The senator from Bedford, Senator Newman.
Madam President, I move that the committee amendment be agreed to.
The question is, shall the committee amendment be agreed to? Those in favor of the motion say aye. Those opposed, no. The amendment is agreed to.
Senate Bill 350, reported from the Committee on Education and Health with a substitute.
The gentleman from Eastern Fairfax County, Senator Saraville.
Thank you, Madam President. I move the committee substitute.
The question is, shall the committee substitute be agreed to? Those in favor of the motion will say aye. Those opposed, no. The substitute is agreed to.
Senate Bill 408, reported from the Committee on the Judiciary with a substitute.
The senator from Enrico, Senator Donovan.
Madam Chairman, I move that the substitute be agreed to. Madam President, I move that the substitute be agreed to.
Question is, shall the substitute be agreed to? Those in favor of the motion will say aye. Those opposed, no. The substitute is agreed to.
Senate Bill 414, reported from the Committee on Education and Health with amendment.
The junior senator from Virginia Beach, Senator Kiggins.
Madam President, I move that the committee amendments be agreed to.
The question is, shall the committee amendment be agreed to? Those in favor will say aye. Those opposed, no. The committee amendment is agreed to.
Senate Bill 448, reported from the Committee on Education and Health with a substitute.
The senator from Northwestern Fairfax County, Senator Boysko.
Thank you, Madam President. I move that the substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor will say aye. Those opposed, no. Substitute is agreed to.
Senate Bill 600, reported from the Committee on Education and Health with amendments.
The senator from Washington, Senator Pillion.
Madam President, I move the amendments be agreed to.
Question is, shall the committee amendment be agreed to? Those in favor of the motion will say aye. Those opposed, no. The amendments are agreed to.
Senate Bill 694, reported from the Committee on the Judiciary with a substitute.
Senator from Rockingham, Senator Obenshain.
Madam President, I move that the committee substitute be agreed to.
Question is, shall the committee substitute be agreed to? Those in favor of the motion will say aye. Those opposed, no. The substitute is agreed to.
Senate Bill 714, reported from the Committee on Education and Health. Senate Bill 718.
Madam President.
The senator from Bath, Senator Deeds.
On 714, a fiscal impact statement came out after this bill was reported, and accordingly, I would move that Senate Bill 714 be re-referred to the Committee on Finance and Appropriations.
The question is, shall Senate...
We just pull it out of the block and come back.
Oh, I'm sorry. But without objection, the bill is out of the block.
Senate Bill 718, reported from the Committee on the Judiciary. Senate Bill 724, reported from the Committee on Education and Health.
The question is, shall the Senate bills now be engrossed and advanced to their third reading? That is, all bills except for Senate Bill 714 on page 23. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The bills are now engrossed and advanced to their third reading.
Returning to page 23, Senate Bill 714.
Madam Chair.
Senator from Bath, Senator Deeds.
Thank you, Madam Chair. I would respectfully remove that Senate Bill 714 be re-referred to the Committee on Finance and Appropriations.
Question is, shall Senate Bill 714 be re-referred to the Committee on Finance and Appropriations? Those in favor of the motion will say aye. Those opposed, no. The ayes have it. The bill is re-referred.
Regular calendar. Senate bills on second reading. Senate Bill 13, a bill relating to energy performance-based contracts, roof replacement. Reported from the Committee on Agriculture, Conservation, and Natural Resources with a substitute, and from the Committee on General Laws and Technology.
The Senator from Arlington, Senator Favola.
Thank you, Madam President. Madam President, I move that the substitute from the Committee on Ag, Conservation, and Natural Resources be agreed to.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Favola.
Thank you, Madam President. I move that the bill be engrossed in advance to its third constitutional reading.
The question is, shall Senate Bill 13 be engrossed in advance to its third reading? Those in favor will say aye. Those opposed, no. The ayes have it. The bill is engrossed in advance to its third reading.
Senate Bill 24, a bill relating to eviction diversion pilot program, expiration report. Reported from the Committee on General Laws and Technology.
The Senator from Hampton, Senator Locke.
Thank you, Madam President. I move that Senate Bill 24 be engrossed in advance to its third reading.
The question is, shall Senate Bill 24 be engrossed in advance to its third reading? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The bill is engrossed in advance to its third reading.
Senate Bill 129, a bill relating to definitions. Cremate, crematory, aquamation. Reported from the Committee on General Laws and Technology with a substitute.
The junior senator from Richmond City, Senator Morrissey.
Thank you, Madam President. Madam President, I move that the substitute from the Committee on General Laws and Technology be agreed to.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Morrissey.
Thank you, Madam President. Madam President, I move that Senate Bill 129 be engrossed and advanced to its third constitutional reading.
The question is, shall the bill be engrossed in advance to its third reading? Those in favor of the motion will say aye. Those opposed, no. The bill is engrossed in advance to its third reading.
Senate Bill 199, reported from the Committee on General Laws and Technology.
The Senator from Williamsburg, Senator Mason.
Let me see, Madam. Oh, thank you, Madam President. I move the bill be engrossed in advance to its third reading. I beg your pardon, ma'am.
The question is, shall Senate Bill 199 be engrossed in advance to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed in advance.
Senate Bill 200, a bill relating to the Freedom of Information Act, record exclusions, administrative investigations, on-site sewage complaints. Reported from the Committee on General Laws and Technology with amendment.
The senior senator from Chesterfield, Senator Hashmi.
Thank you, Madam President. I move the committee amendment be agreed to.
The question is, shall the committee amendment be agreed to? Those in favor of the motion will say aye. Those opposed, no. The amendment is agreed to. Senator Hashmi.
Madam President, I move that SB 200 be engrossed in advance to its third reading.
The question is, shall the bill be engrossed in advance to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed in advance to its third reading.
Senate Bill 297, a bill relating to stay of debt collection activities by healthcare providers, prohibited practice under Virginia Consumer Protection Act. Reported from the Committee on General Laws and Technology with amendment.
Senator from Bath, Senator Deeds.
Thank you, Madam President. With a recommendation that it be rejected, I move that the amendment from the Committee on General Laws and Technology be agreed to. I'd like to speak to that amendment, if I could.
All right. So taking it up one at a time, with the recommendation that it be rejected.
With the recommendation that it be rejected. And I offered the amendment in committee because I thought it might placate the opponents, but it did not. And upon reflection, the amendment simply repeats language that's already in the law. And so it's therefore repetitive and unnecessary. And so that's the genesis for my recommendation.
With the recommendation that the committee amendment from the Committee on General Laws and Technology be rejected, the question is, shall the committee amendments be agreed to? All in favor of the motion will say aye. Those opposed, no.
No.
The committee amendment is rejected.
Now I move that the bill be engrossed and advanced to its third reading.
Question is, shall the bill be engrossed and advanced to its third reading? All those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 309, a bill relating to the Consumer Protection Act, prohibited practices, certain restrictive provisions in contract or written agreement, reported from the Committee on General Laws and Technology.
The senator from Roanoke City, Senator Edwards.
Yeah, Madam President, I move that Senate Bill 309 be engrossed and advanced to its third reading.
The question is, shall Senate Bill 309 be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 341, a bill relating to consumer protection, online marketplace, high-volume third-party sellers, reported from the Committee on General Laws and Technology with a substitute.
The senator from Southern Fairfax County, Senator Barker.
Thank you, Madam President. I move that the substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Barker.
Yes, I move that it be engrossed and advanced to its third reading.
Question is, shall the bill be engrossed and advanced to its third reading? Those in favor of the motion will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 375, a bill relating to optometrist laser surgery, reported from the Committee on Education and Health with amendments, and we have one floor amendment.
The senator from Fairfax City, Senator Peterson.
Thank you, Madam President. Move to waive the reading of the floor amendment.
We have to accept the committee substitute.
Move to accept the committee substitute.
The question is, shall the committee substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The committee amendment is agreed to. Senator Peterson.
Thank you, Madam President. Move to waive the reading of the floor amendment.
The question is, shall the reading of the floor amendment be waived? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The reading of the floor amendment is waived. Senator Peterson.
Thank you, Madam President. This is the optometrist laser bill, and so just a brief bit of context. We put amendments on in Health Committee, and this is yet another enactment which adds a self-reporting requirement to the current enactments that deal with certification and oversight, and it would basically put us in a position that we are matched up with that mythical body down the hall as we push this towards passage. So with that, I move the amendment.
The question is, shall the floor amendment be agreed to? Those in favor of the motion will say aye. Those opposed, no. The ayes have it. The floor amendment is agreed to. And again, Senator Peterson.
Thank you, Madam President. I move that the bill be engrossed and moved along to third reading.
The question is, shall the bill be engrossed and advanced to its third reading? Those in favor of the motion will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 393, a bill relating to Consumer Data Protection Act, data deletion request, reported from the Committee on General Laws and Technology with a substitute.
The senator from Alexandria, Senator Eben.
Thank you, Madam President. I move the committee substitute.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Eben.
Thank you. I move SB 693 be engrossed and advanced to its third reading.
The question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 431, a bill to direct the Board of Education to recommend as best practice the shortest duration of quarantine possible for students and employees who contract COVID-19 and to develop and recommend to schools test-to-stay guidelines for use as an alternative to quarantine for students and employees who contract COVID-19. Reported from the Committee on Education and Health with a substitute.
The senator from Enrico, Senator Donovan.
Madam President, I move the committee substitute.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. The substitute is agreed to. Senator Donovan.
Madam Chairman, I waive the reading of the floor substitute.
That's not.
I don't have a floor substitute.
That's not this one.
Wrong bill.
Is there?
Pardon me, Madam President. I move that we engross and advance to its third constitutional reading. Thank you.
The question is, shall Senate Bill 431 be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 519, a bill relating to casino gaming, sale and consumption of alcoholic beverages, and casino gaming establishments, casino employees, wagers, accounting, and games. Reported from the Committee on General Laws and Technology with a substitute.
The gentlelady from Portsmouth, Senator Lucas.
Thank you, Madam President. Madam President, I move that the substitute be agreed to.
The question is, shall the substitute be agreed to? Those in favor of the motion will say aye.
Aye.
Those opposed, no. Substitute is agreed to. Senator Lucas.
Yes, Madam President, I move that the bill be engrossed and advanced to its third constitutional reading.
Question is, shall the bill be engrossed and advanced to its third reading? Those in favor of the motion will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 656, a bill relating to the Board of Education policy on sexually explicit instructional material. Reported from the Committee on Education and Health with a substitute, and there is a floor substitute.
Senator Donovan, the senator from Enrico.
Madam President, with the recommendation that we reject the committee amendment, I move that amendment.
First, you have to reject the substitute.
I'm sorry. With the recommendation we reject the committee substitute, I move that substitute.
Question is, with the recommendation that the substitute be rejected, the question is, shall the substitute be agreed to? All in favor of the motion will say aye. Those opposed, no. No. Substitute is rejected. Senator Donovan.
Thank you, Madam Chairman. I now move waiving of the floor substitute.
The question is, shall the reading of the floor substitute be waived? Those in favor will say aye.
Aye.
Those opposed, no. The reading of the floor substitute is waived. Senator Donovan.
Thank you, Madam President. The floor substitute is the same substitute as we had in the committee with one change, and that is reference to the appropriate part of the code. In committee, council read sexually explicit visual content code language, and this directs you to the correct code section that is simply sexually explicit content. It was just a technical change to get to the right section of the code. And with that, I move the floor substitute, Madam President.
The question is, shall the floor substitute be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The floor substitute is adopted. Again, Senator Donovan.
Thank you, Madam President. I now move that we engross and advance this bill to its third constitutional reading.
The question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The substitute is engrossed and advanced to its third reading.
Senate Bill 662, a bill to require the Department of Education to include certain data on school quality profiles, reported from the Committee on Education and Health.
The senator from Portsmouth. Senator
Thank you, Madam President. I move that the bill be engrossed and advanced to its third reading.
The question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 737, a bill relating to early childhood care and education entities, administration of epinephrine, reported from the Committee on Education and Health with amendments.
The senator from Northwestern Fairfax County, Senator Boysko.
Thank you, ma'am. I move the committee agreements be agreed to.
The question is, shall the committee amendments be agreed to? Those in favor will say aye.
Aye.
Those opposed, no. The amendments are agreed to. Senator Boysko.
Madam President, I move the bill be engrossed and advanced to its third reading.
The question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Senate Bill 739, a bill relating to public elementary and secondary schools and public school-based early childhood care and education programs, student instruction, reported from the Committee on Education and Health with amendments.
Senator from Enrico, Senator Donovan.
Thank you, Madam President. May that bill go by for the day.
Without objection, Senate Bill 739 goes by for the day.
Senate Bill 764, a bill relating to public bodies, security of government databases, and data communications, reported from the Committee on General Laws and Technology with amendments.
The senator from Southern Fairfax County, Senator Barker.
Thank you, Madam President. I move that we adopt the amendments.
Question is, shall the committee amendments be adopted? Those in favor will say aye.
Aye.
Those opposed, no. The committee amendments are adopted. Senator Barker.
Thank you. I move that we have the bill engrossed and advanced to its third reading.
Question is, shall the bill be engrossed and advanced to its third reading? Those in favor will say aye. Those opposed, no. The bill is engrossed and advanced to its third reading.
Uncontested calendar, Senate bills on first reading.
Senator from Fairfax County, Senator Saslaw.
Madam President, I move that all Senate bills on first reading on the uncontested and regular calendar, that's pages 32 through 34, Senate Bill 622 through 722, that the rules be suspended and the first constitutional reading of the titles be dispensed with.
The question is, shall the rules be suspended and the first reading of the titles of Senate bills on the uncontested and regular calendar on pages 32 through 34, Senate Bill 622 through 722, be dispensed with? All in favor of the motion will record their votes aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Does any senator desire to change their vote? The clerk will close the roll.
Ayes 37, no 0.
Ayes 37, no 0. The reading of the titles is dispensed with. The senior senator from Fairfax County, Senator Saslaw.
Madam President, I now move that those said bills be passed by for the day.
The question is, shall the Senate bills on the uncontested and regular calendars now on second reading be passed by for the day? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The bills will now go by for the day.
Uncontested calendar, Senate Joint Resolutions on second reading. Senate Joint Resolution 83, confirming appointments by the governor of certain persons communicated to the General Assembly January 21st, 2022, reported from the Committee on Privileges and Elections, and there is a floor amendment.
Madam President.
The senator from Alexandria, Senator Eben.
Could SJR 83, 84, and 85 go by for one more day before engrossment?
Without objection, sir. Senate Joint Resolutions 83, 84, and 85 now go by for the day. The senior senator from Fairfax County, Senator Saslaw.
Madam President, I inquire of the clerk, does that complete the calendar for today?
Yes, sir.
Thank you.
Is there any other business to come before the Senate? The senator from Hampton, Senator Locke.
Thank you, Madam President. I rise on a point of personal privilege.
The senator has the floor.
Thank you, Madam President. Madam President, February 1st was the start of Black History Month, which was founded by a Virginian, Dr. Carter G. Woodson. Dr. Woodson's vision was to preserve the history of African Americans. He noted that African American contributions were overlooked, ignored, and even suppressed by the writers of history textbooks and the teachers who used them. Dr. Woodson initiated Black History Week in 1926, and the month of February ultimately was designated Black History Month in 1970. Despite this designation, there are still those who ask, why do we need a Black History Month? Why? Because despite having occupied this land for over 4 centuries and contributing to its growth and development, African Americans are still confronted with innumerable odds. On the first day of Black History Month 2022, 12 historically Black colleges and universities, including my alma mater, received bomb threats, disrupting the learning environment and distressing students and their families. 17 campuses have received these threats over the past week. These threats were made by a group of self-identified white supremacists and neo-Nazis. 6 juveniles are now under investigation by the FBI for these incidents. I, like many of you, should be angry about this and so many injustices faced by Black and brown communities. But then I think back to the quote from Nobel Prize and Pulitzer Prize winning author Toni Morrison, who herself has gotten vilified around here, who once said, I get angry about things, then go on and work. African American men and women have always had things to be angry about. And today, like many days before, we have to just get to work. It is easy to get lost in the anger, and we are certainly justified in our anger. Anger at those who bombed the 16th Street Baptist Church in 1963, killing beautiful young Black girls in Birmingham, Alabama. Angry at Dylan Roof, who walked into Mother Emanuel African Methodist Episcopal Church in Charleston, South Carolina in 2015, and murdered 9 people who welcomed him into their sanctuary. Anger at our colleges and universities are under threat today, but instead of succumbing to that anger, instead of sinking to the level of the terrorists, we go on and work. Work like the heroes of the civil rights movement who picked up the pieces in Alabama and forged and went on to demand equality and justice. Work like Denmark Vesey, one of the founders of Mother Emanuel AME Church in Charleston, who in the late 1700s rallied roughly 9,000 enslaved men and women at what would have been the largest revolt against slavery on American soil had they not been sold out. We work like the men and women who rebuilt the church after it burned to the ground in the wake of his attempted revolt and Vesey's lynching, and those who picked up the pieces after the 2015 murders. We get angry, but we work. Like legal professionals, Supreme Court Justice Thurgood Marshall and his mentor, Charles Hamilton Houston, who was the strategist for ending separate but equal in the United States. Or the Tuskegee Airmen, who served in a segregated army, but still worked to complete over 15,000 bomber missions to free Europe from the grips of Hitler's Nazis during World War II. We get angry, Then we go on and work. A young student at Spelman College, one of the HBCUs subjected to one of the bomb threats last week, said that she was more disappointed and annoyed than anxious following the threat. She said, and I quote, "A lot of time has passed for us to keep going through the same patterns of racism." She is right on 2 points. One, it has been a long pattern of racism. Too long as generation after generation face the same battles. Secondly, like the walls of Mother Emanuel, we still stand. We push through and we work. We work despite efforts to take us back and silence our voices. We do so for all of the named and unnamed African Americans who contributed to make this a more perfect union over the past 400 years, until our fellow Americans see the humanity in all of us, irrespective of race, ethnicity, creed, sexual preference, gender identity, or religion, or whatever the difference. Then we may very well get angry about things. But more importantly, we will dig in our heels and go on and get to work. Thank you, Madam President.
Is there any other business to come before the Senate? Hearing none, the clerk will now report any announcements on the desk.
Announcements for Monday, February 7th, 2022. The Committee on Commerce and Labor will meet 15 minutes after adjournment in Senate Room A, Pocahontas. The Education and Health Subcommittee on Higher Education will not meet today. This is a change. The Finance and Appropriations Subcommittee on Health and Human Resources will meet at 4:00 p.m. in Subcommittee Room 1, 5th floor, Pocahontas. Senators Howell, Hanger, Vogel, Barker, Deeds, Eben, and McClellan. For Tuesday, February 8th, 2022, the Finance and Appropriations Subcommittee on Economic Development and Natural Resources will meet at 7:30 a.m. in Subcommittee Room 1, 5th floor, Pocahontas. Senators Marsden, Ruff, Howell, Saslaw, Hanger, and Barker. The Finance and Appropriations Subcommittee on General Government will meet at 7:30 a.m. in Subcommittee Room 2, 5th floor, Pocahontas. Senators Peterson, Newman, Lucas, Vogel, Locke, and Eben. The Committee on Finance and Appropriations will meet at 8:30 a.m. in Committee Room B, Pocahontas. This is a time change. The Democratic Caucus will meet at 11:00 a.m. in Senate Room 1 in the Capitol. The Republican Caucus will meet at 11:30 a.m. in Senate Room 2 in the Capitol.
The chair now recognizes the President pro tempore, Senator Lucas.
Thank you, Madam President. Madam President, I move that the Senate do now adjourn until 12 noon tomorrow.
The question is, shall the Senate adjourn until 12 noon tomorrow? All in favor of the motion will say aye. Those opposed, no. The motion is agreed to. The Senate now stands adjourned until 12 o'clock noon tomorrow.